Good morning. This is the October 3rd Tennessee Court of Appeals docket. Thank you for bearing with us while we work through some technical issues this morning. My name is Neil McBrayer. I am joined virtually by Judge Arnold Golden and here in the courtroom, Judge Jeffrey Usman. Most of those in the courtroom know that yesterday the AOC announced the sad passing of our friend and colleague, Judge Richard Dinkins. And so, as a matter of personal privilege, the court would like to ask for a moment of silence and recognition for his long service to Tennessee courts. So if you will join me now in a moment of silence. Thank you. The procedure this morning is appellates will have 15 minutes to argue their position. They can reserve up to 5 minutes for rebuttal time. Ask the appellant once they come to the podium to, after introducing themselves, to indicate how much time they would like to reserve for rebuttal. We have 3 cases on this morning docket, and if there is no preliminary matters that we need to take up, I'll ask the clerk to call the first case.
Samuel Forrester Hunter versus Winnie Sue Cooper.
May it please the court, my name is Jacob Vanson, and along with my co-counsel Donald Caparella, I represent Dr. Samuel Hunter. I'd like to reserve 3 minutes for rebuttal.
Thank you, Mr. Vance.
Tennessee Code annotated 366106A contains 2 statutory requirements that courts must follow when fashioning a parenting plan. First, the statute says the decisions regarding the parenting plan shall be made on the basis of the best interest of the child. Second, the statute states the court shall order a custody arrangement that permits both parents to enjoy the maximum participation possible in the life of the child. We acknowledge that the first mandate, the one of best interests, is of greater weight than the second, that of maximum participation. However, the maximum participation requirement is still a requirement. As this court has said in Roundtree v. Roundtree, quote, Tennessee courts must now fashion custody arrangements so as to give each parent the maximum amount of time possible with the child in accordance with the child's best interests, unquote. Or, phrased differently, the court must award the maximum time with each parent unless doing so is not consistent with the child's best interest. In Flynn v. Stevenson, this court held that there are a myriad number of factors that could support a parenting plan that does not provide equal time for both parents. But, the Flynn court said, in cases where such a conclusion is supported by the evidence, it's incumbent upon the trial court to say so in express findings of fact contained in its written order. And if the trial court does not say so, it's reversible error. The trial court in this case...
Isn't that what the trial court has done here, though, by saying the best interest of the child and going through the best interest factors provide that this is the appropriate plan in terms of how time should be shared here?
Not exactly, Your Honor. The trial court did have extensive findings of fact and conclusions of law in its memorandum opinion. But in that same opinion, the trial court never considered the maximum participation principle. And in fact, this isn't even a scenario where the trial court considered the maximum participation principle. But
so are you suggesting a per se rule here that if a trial judge does not reference 106A or the magic phrase maximum participation possible, that it needs to be reversed or vacated?
Not a per se rule, Your Honor. because there are examples where this court has, in regards to the best interest analysis, said, well, actually, I can't think of any examples where the court has actually said, you didn't mention best interests, therefore we're not going to remand. I think if some judge didn't mention best interest at all, this court might be likely to remand because the judge wouldn't have properly analyzed a significant requirement that's in the statute. I think this is the same way, but I wouldn't call it a per se rule, because what this court has said regarding the various factors that have to be analyzed under 36.6.106A is it's not incumbent upon the court to mention every factor on the list, but it is incumbent upon the court to consider every factor on the list. And here, there's no evidence that the trial court considered the maximum participation requirement at all. In fact, the evidence is actually the opposite. The evidence is that the trial court did not consider the maximum participation requirement. It's actually interesting, in the trial court's detailed findings, fact, conclusions law, the trial court does mention best interest. The trial court mentions several other standards from, I have trouble pronouncing it, but I believe it's the Darvamanish case, regarding when equal time is warranted and not warranted and how the court analyzes that. But it did not ever reference the statutory requirement of maximum participation, and moreover, created a parenting plan that did not apply the maximum participation requirement. We're here on an abusive discretion standard, right? And so in order to prevail, Dr. Hunter has to prove, well, establish that the trial court did not identify and apply the most appropriate legal standards to the decision, right? That's what the abuse of discretion, one of the three ways in which a trial court can abuse its discretion, right?
Counsel, I'm still struggling to see the gap between the question Judge Breyer asked and your indication that this isn't creating a per se rule. It seems like if we find for your client here, then the trial judge must state, reference, maximum participation, cite the relevant subsection of the statute. How are we not creating that rule if we adopt your position here?
Because if the trial court makes it clear that they considered the maximum participation requirement, even if they don't mention it by name, that's enough. And that would be the gap between the two, right? It's kind of like...
Well, wouldn't a reference, though, to circumstances under which equal parenting time would be appropriate suggest that the court was factoring in maximum participation?
Respectfully, no, Your Honor, because there's a large gulf between the amount of time that Dr. Hunter actually did receive and equal parenting time. And in fact, there is one case, I believe it was Woody v. Woody, where the father received 120 days and was arguing for equal time. And the court did not...
Yeah, but Woody against Woody seemed to hinge a great deal on the court's misapplication or improper application of the tender years doctrine. It seems to me makes Woody against Woody sort of an outlier, distinguishable case from those circumstances where we find abuse of discretion.
So I'll give you another example then, which would be, this would be the case of Strickland v. Strickland, I believe it is, where in the Strickland v. Strickland case, this court remanded the case for the court to enter a parenting plan that afforded, I believe it was mother in that case, more time, though not as much time as father. It specifically said more time, but not as much time as father. And I think it's important to reiterate that we're not talking about just kind of general case law here or something the courts over the years have established. We're talking about a statutory requirement that the legislature put into the statute. It's not even just one of the factors that the court's required to analyze. It's specifically something that the legislature said the courts, when making their custody determinations, shall create a parenting plan that maximizes best interest. And if the trial court never, not only in this case they never mentioned it, but there's no indication that they actually considered it outside of the one reference to equal time not being
if you're not advocating for a per se rule, is there a magic ratio then that we're looking at so that the ratio of one parent's days versus the other would trigger this concern that 106A was ignored?
No, I don't have a magic ratio this court would look at. The way I think this court should frame the rule is that trial courts should start by saying, okay, I'm required to impose a parenting plan with equal time, because that would be maximizing the time. But I find it not to be in the best interest of the child to have equal time because of X, Y, and Z, and spell it out why it's not in the child's best interest of equal time. And for every deviation downward from equal time, whatever that deviation might be, the trial court, should be required to explain why it is deviating downward in that way. Just like, for instance, in this case, we have a scenario where the trial court, on the record, complimented many number of times Dr. Hunter's performance over a 2-year period of spending time with his child, right? The child was very young. And Dr. Hunter had what, by all accounts, is a great record of, for 2 years, picking up the child at 5 o'clock every day, dropping her back off at 7 o'clock every day, 4 out of the 5 days of the week. The other 5th day of the week, Friday, he actually got to keep the child overnight. And then he had a great record of taking the child to do interesting and fun and enriching things on that day. And the court complimented him, talked about how this has created a greater bond with the child, and how the child, has a bond with her father now. But yet, when the court actually fashioned its parenting plan, it reduced Dr. Hunter's midweek parenting time from 4 days a week to 2 days a week. And there's no rational explanation for that, and especially no rational explanation for that that's explained in the record. And we think in that scenario that the court cannot be held to have properly identified and applied the factors when there's no mention of the factor, and clearly if it had applied the factor on its own rulings, on its own findings of fact, it would have come out differently. I want to mention one other thing.
Counsel, is the temporary plan supposed to be a default, though? Is it supposed to be its own starting point for fashioning what the ultimate plan is going to be?
No, it's not, Your Honor. And actually, the statute makes clear that the temporary plan shall not create a presumption in favor of it when fashioning the final plan. However, this court's case law has also made clear that when a temporary parenting plan is in place for a long time, the court can consider that, and I cite several cases in my brief, the court can consider that in fashioning the ultimate plan. I think there's one case, I can't remember exactly which case name it is, but this court said something along the lines of, we can't ignore what's happened for the past 4 years. Well, granted, this isn't 4 years, it's only 2 years, but we have a 2-year record of father spending quality bonding time with his child, of the child benefiting from that, and then the court backing time away. I also want to mention the fact that the court inexplicably gave father only 2 weeks of parenting time during the summer, while saying this court is required to fashion a parenting plan that kind of grows with the child as the child grows older. Yet still, it only gave the child, who was in daycare at the time, 2 weeks during the summer. Well, as the child gets older, the child's going to be in school. In fact, the court required the parties to kind of follow the Williams County Schools schedule. Child's going to be in school, and there would be an opportunity for the child to spend more time with father. And if the court were truly applying the maximum participation principle, then the court would have awarded more time with father during summer. But it didn't, and it did not explain why. And in order to facilitate appellate review, as this court has said many, many times, it's incumbent upon a trial court, when making rulings, analyzing the best interest of the child, to explain why it is making the decisions it's making. And here, the court did not explain why it was only granting father 80 days per year, which is a notably lopsided parenting plan. So I welcome any more questions if the court has any, but since my time is running short, I'll reserve the remainder of my time for rebuttal. Thank you.
All right, thank you, Mr. Vance. We'll hear from the appellee.
Good morning. My name is Edward Schell. I'm a member of the Williamson County Bar, and I'm here on behalf of Ms. Cooper. Like the appellant's counsel, I was not involved in the trial of the case, was just brought in to handle the appeal. And,
Can you pull that mic up, please?
I'm sorry?
He was
Pull the
asking you to
mic
pull
up.
your little mic a little closer.
Okay, or I'll try to stand. Is that better, Judge?
Yes, thank you.
As I read their brief and interpret their argument, I think they are effectively asking the court to look at this aspirational goal of maximizing the parenting time as an additional factor under the statute. None of the case law that they have cited stands for the proposition that it's a reversible error for a trial judge to fail to include in writing in their ruling that he's considered this aspirational goal. It's just simply not there.
Michelle, I mean, I know you're very familiar with these types of parenting plans. And what's striking about this case is 80 days for father. Yes, we see 80-day cases, but normally there's some sort of 406 factor that has played into that determination, some reason why that parent should not have gotten more parenting time. And we don't have that here. And it really does sort of stand out like a sore thumb in this case, just 80 days. I mean, how do we explain that in light of the requirements of the statute?
I think by looking at the way the court analyzed the factors, this memorandum and opinion that you've probably seen is about 70 pages in length, and the only issue that
No one's
is
going to
addressed
accuse
there-
Judge Martin of doing a poor job of putting together findings and facts and conclusions of law, that's
Yeah.
for sure.
He did. It's more detailed than almost any that I have ever read. And at the end of the day, he found that almost all of the factors weighed in favor of mother. And to suggest that if the judge had said in writing, I've considered this aspirational goal, but I'm going to rule in this way, there's no guarantee that he would have given the father any more time just by virtue of putting that in the order. I think that if the legislature intends that this aspirational goal be given the same weight as a factor under the statute, they can amend the statute to that effect. On the issue of the permanent versus temporary parenting plan, I think counsel is correct. There's no presumption in favor of it, but at the end of the day, there's only a difference of 8 hours over a period of 2 weeks that Dr. Hunter is not visiting with a child compared to the temporary plan. And in these cases, there are always various reasons why a temporary plan does not translate very well to a permanent plan.
Counsel, why doesn't it translate here? It seems like the judge thought this was working pretty well. The parties seem to have thought it was working pretty well. Why the reduction here?
I can't really answer that question, Your Honor. Judge Martin didn't address it in that way. I think that by the way he analyzed the factors, he just determined that this plan was in the best interest of the child. And I think having heard the witnesses over a period of about 8 days it took to try this case, he formulated his own opinions about the witnesses and about the parents and their connection with the child, and just decided that that was the thing to do. I want to address some of these cases that were cited in the appellant's brief just by way of distinguishing them. The first one they rely on is the Flynn versus Stevenson case. But the reason why the court reversed on that case is the trial court had made no findings of fact supporting its parenting plan and didn't even make any reference to the statute. So that's clearly different than what we have here. The court in Flynn also cited the Cannon case, which said father's argument suggests that permitting both parents to enjoy the maximum participation possible in the child's life should be the court's primary consideration in ordering a custody arrangement. This is not the case. The plain language of the statute says that you only apply the maximum participation standard as long as it's consistent with the child's best interest. Reference was made to the Woody case, and I tend to agree, Judge, with your assessment of that. This was rather an outlier. The problem in that case was that the trial judge seemed to have based his residential schedule solely on the minor child's age and gender. But again, it doesn't stand for the proposition that it's mandatory to address this maximization portion of the statute. The appellant also cites the Gooding case, but again, in that case, it wasn't the failure to mention the maximization part of the statute, it's that the trial court failed to make findings of fact as required by Rule 52. And there's nothing to suggest that the remand was based on a failure to mention the aspirational goal of maximizing the parent's time. The appellants also cited to the Barnes case in their brief, claiming that a father receiving 85 days per year was notably lopsided. The problem in that case was that the trial judge had based his custody decision solely on the father's child support history. And having found that, I guess the father did not pay regularly, they used that as a basis to only award him 85 days per year. But again, that case, along with all the others, simply doesn't stand for the proposition that it's reversible error for a trial judge not to refer to this maximization. And unless the court has questions, I'll rely on my brief. I don't see Judge Golden anymore.
All right. Thank you, Mr. Shell.
Thank you.
We'll hear from Mr. Vance on rebuttal.
I want to make a couple of points just real quickly.
Yeah, Mr. Vance, before you start, let me just make sure, is Judge Golden on the monitor?
I can hear it.
Oh, he can-
Okay, very good. Okay, he can hear.
I see
All
Judge
right.
Golden.
Okay, very good.
Thank you.
I want to make a couple things clear. The abusive discretion standard requires this court to look at whether or not the trial court identified and applied the appropriate legal principles, right? And we've had a lot of discussion today about whether or not the trial court identified the statutory maximization requirement in its memorandum in order. But it's not enough for the trial court just to identify it. It has to identify it and apply it. And in my brief, I go through all the ways in which the trial court in this court failed not only to identify the statutory maximization principle, but also to apply the statutory maximization principle to this case. I also want to note that even if this court does not want to go as far as adopting a per se rule that the trial court has to start with the maximization principle and then back down from that principle in order to get to the right parenting plan in the best interest of the child, even though that would be a great per se rule, and I think that's what the statute requires. The court doesn't have to go that far in this case. It would be enough in this case if the court just says, kind of like it said in Flynn v. Stevenson, if the trial court is going to come down from the maximization principle, if it's going to say the maximization principle does not work here and here's why, it's incumbent upon the trial court to say why in its order. And part of the reason for that is for appellate review. This court needs to be able to see why the trial court is not applying certain statutory requirements, whether they be mandatory, directory, or however you phrase them. This court needs to be able to see why in order to facilitate meaningful appellate review. All of the ways in which anyone could say that Judge Martin applied the maximization principle in this case are purely speculative, because he didn't say, I'm applying the maximization principle. And I think it's noteworthy, as I mentioned in my first argument, that he mentioned a heck of a lot of other principles in his vast opinion, but never brought up the statutory maximization one. And I think the reason why is because he did not consider the statutory maximization principle. My learned co-counsel mentioned the 8 hours drop in parenting time. And we're not arguing, let's just go back to the temporary plan. What we're arguing is even the temporary plan wasn't enough. I mean, Dr. Hunter was seeing his child very little during the temporary plan. The court should fashion a plan that maximizes Dr. Hunter's time in accordance with the best principles of the child. That's all I have. Thank you, Your Honors.
Thank you, Mr. Vance. The case is submitted. We thank counsel for both parties. Thank you. You'll call the next case, please.